Hello everyone, my name is Jonathan Dawid and I'm a barrister at Brick Court Chambers in London, practicing in commercial litigation and arbitration. Please note that everything I say today is my own personal view and doesn't necessarily represent the views of other members of Chambers. Today's topic is remote hearings in international arbitration. Parties and tribunals around the world are having to adapt to the challenges of lockdowns, quarantines and social distancing. As a result, the traditional arbitration hearing is, at least for the moment, a thing of the past. Even as countries emerge from strict lockdown, continuing restrictions means that getting everyone physically into the same room at the same time is often not possible. So what are the options if COVID-19 means that an in-person hearing can't go ahead? There are essentially four possibilities. Firstly, to delay the hearing until normality is restored and it can proceed in person. Second, to have a purely written proceeding, in other words, no hearing. Third, to hold a remote hearing on a platform such as Zoom or Skype for Business. And fourthly, to have a hybrid procedure involving a mix of written, remote, and potentially even pre-recorded materials, for example, a US-style witness deposition. Which approach is most appropriate will depend on a wide range of factors. There's certainly no one-size-fits-all answer, and it will be very much a matter of tailoring the procedure to the case at hand. And that's where one of the key advantages of international arbitration, namely its flexibility, really comes to the fore. The flip side of flexibility, however, is that there's a lot more to disagree about. So what's the situation if you can't agree, or if the tribunal doesn't like what you've agreed? Well, for an English-seated arbitration, the procedure needs to meet the requirements of the Arbitration Act 1996. Section 34(1) of the Act states that it shall be for the tribunal to decide all procedural and evidential matters subject to the right of the parties to agree any matter. Now that last part indicates that the parties' agreement is paramount, so the tribunal can't impose a procedure against the agreement of the parties. And that's also clear from section 68(2) of the Act, which makes it a ground for challenge to an award where the tribunal has failed to conduct proceedings in accordance with the procedure agreed by the parties. If the parties don't agree, however, section 34 gives the tribunal power to select an appropriate procedure. Of course, that doesn't mean the tribunal can do whatever it wants. Section 33 of the Act requires the tribunal always to, and I quote, act fairly and impartially as between the parties, giving each party a reasonable opportunity of putting its case, and dealing with that of its opponents, and to adopt procedures suitable to the circumstances of the particular case, avoiding unnecessary delay or expense, so as to provide a fair means for the resolution of the matters falling to be determined. A procedure which fails to satisfy this will leave the award open to challenge under section 68 of the Act, but only where it has caused or will cause substantial injustice. Given that such a challenge will be heard in courts, an obvious yardstick for considering if a remote procedure has caused substantial injustice is the approach to remote hearings adopted by the civil courts themselves. The approach of the commercial courts in London has been strongly in favour not only of hearing proceedings remotely wherever possible in the current circumstances, but also of adhering as much as possible to pre-COVID timetables. And that suggests that courts are unlikely to be sympathetic to challenges to arbitration awards on grounds that the case was not suitable for remote hearing, or that the tribunal made insufficient allowances for the additional burden of preparing for remote hearing, except in very clear-cut cases. What about the rules of the arbitration themselves? Did they affect the ability of the tribunal to adopt a remote procedure? Well, obviously that depends on the rules applicable to the arbitration at hand. I'm going to consider three of the most common arbitration rules used in English-seated arbitrations: LCIA, UNCITRAL, and ICC. Starting with the LCIA Rules 2014 edition, the key provision is Article 19, Oral Hearings. Article 19.1 provides that any party has the right to a hearing before the arbitral tribunal on the party's dispute at any appropriate stage of the arbitration, as decided by the arbitral tribunal, unless the parties have agreed in writing upon a documents-only arbitration. For this purpose, a hearing may consist of several part hearings as decided by the arbitral tribunal. So what is not possible under the LCIA rules is for the tribunal to dispense with hearings altogether, absent agreement of the parties. It's clear that hearing in this context means an oral procedure, as a hearing on papers would amount to a documents-only arbitration. Further, the right to a hearing is not limited to final or evidentiary hearings. It exists at any appropriate stage. That's not an unqualified right. It's for the tribunal to decide what is an appropriate stage. But it implies that significant procedural disputes should also be dealt with through hearings, rather than a written-only procedure. What about the type of hearing? Here, the LCIA rules give the tribunal a broad discretion. Rule 19.2 provides that the arbitral tribunal shall organise the conduct of any hearing in advance in consultation with the parties. The arbitral tribunal shall have the fullest authority under the arbitration agreement to establish the conduct of the hearing, including its date, form, content, procedure, time limits, and geographical place. As to form, a hearing may take place by video or telephone conference or in person, or a combination of all three. As to content, the arbitral tribunal may require the parties to address a list of specific questions or issues arising from the parties' dispute. So, under the LCIA rules, the tribunal has express power to direct that hearings take place remotely, and it's very hard to see how a party, having agreed to those rules, could object to a remote procedure. Turning to the UNCITRAL Rules 2010 edition, Article 17.3 provides that if, at an appropriate stage of the proceedings, any party so requests, the arbitral tribunal shall hold hearings for the presentation of evidence by witnesses, including expert witnesses, or for oral argument. So, that's very similar to Article 19.1 of the LCIA rules. However, unlike the LCIA rules, the UNCITRAL rules don't make express provision for wholly remote hearings. Indeed, Article 28.1 of the UNCITRAL rules, which requires the tribunal to give the parties notice of the place of a hearing, might be said to assume that the hearing will have a single physical location, i.e. a place. Further, while Article 28.4 states that the arbitral tribunal may direct that witnesses, including expert witnesses, be examined through means of telecommunication that do not require their physical presence at the hearing, such as video conference, no mention is made in the rules of the tribunal being able to direct that other participants attend a hearing remotely. On the other hand, Article 17.1 of the UNCITRAL rules provides that, subject to these rules, the arbitral tribunal may conduct the arbitration in such manner as it considers appropriate, provided that the parties are treated with equality and that at an appropriate stage of the proceedings, each party is given a reasonable opportunity of presenting its case. In the absence of any clear prohibition on remote hearings, that's likely to be sufficient to enable the tribunal to order hearings to take place fully remotely. Indeed, that is the assumption in UNCITRAL's own 2016 notes on organising arbitral proceedings, which state that hearings can take place in person or remotely. While this is just guidance and has no legal force, it's obviously persuasive, and it's unlikely a tribunal will be swayed by arguments that it doesn't have power under the UNCITRAL rules to order a hearing to take place wholly remotely. I should add that the 2010 UNCITRAL rules differ in some significant respects from the 1976 and 1998 versions, and nothing I say here should be taken as applicable to those earlier versions. What about the ICC rules? Again, I'm just going to look at the most recent version here, the 2017 ICC rules. So if you're arbitrating under an earlier version, please look them up yourselves. The ICC rules relating to hearings differ from the LCIA and the UNCITRAL rules in a number of important respects. Firstly, the ICC rules expressly recognise two different kinds of hearing: procedural hearings, i.e. CMCs, and substantive hearings. Article 24 of the ICC Rules requires, in each case, that a CMC be held to consult the parties on procedural measures that may be adopted. Further, as provided for in Article 22.2 of the ICC Rules, following the CMC, the Tribunal may adopt such procedural measures as it considers appropriate, provided that they are not contrary to any agreement of the parties. So it's very clear that under the ICC Rules, any agreement of the parties as to procedure to be adopted trumps the views of the Tribunal. That's unlike Article 14.2 of the LCIA Rules, for example, which provides only that the parties may agree on joint proposals for the conduct of their arbitration for consideration by the arbitral tribunal. Article 24.4 of the ICC Rules expressly provides that case management conferences may be conducted through a meeting in person, by video conference, telephone, or similar means of communication. In the absence of an agreement of the parties, the arbitral tribunal shall determine the means by which the conference will be conducted. So it is clear that under the ICC Rules, CMCs can be conducted remotely if the parties don't agree on the procedure. What about substantive hearings? Article 25.2 states that after studying the written submissions of the parties and all documents relied upon, the arbitral tribunal shall hear the parties together in person if any of them so requests. The reference to a hearing in person seems to be clear that the parties have a right to a physical hearing, and that's supported by a comparison with the corresponding provision of the CMCs in Article 24.4, which distinguishes between meeting in person and video conference. However, on the 9th of April 2020, the ICC issued a guidance note according to which Article 25.2 does not preclude a tribunal from imposing a remote proceeding, even if a party objects. According to this note, while Article 25.2 of the rules provides that after studying the written submissions of the parties and all documents relied upon, the tribunal shall hear the parties together in person if any of them so requests, this language can be construed as referring to the parties having an opportunity for a live adversarial exchange and not to preclude a hearing taking place in person by virtual means if the circumstances so warrant. Finally, in that respect, if an ICC tribunal directs a remote hearing over the objections of a party, in order to challenge a subsequent award under Section 68 of the Arbitration Act, an aggrieved party would have to establish not only that this was contrary to Article 25.2 of the ICC Rules, but also that they suffered substantial injustice as a result. Thus, whatever the correct reading of the ICC Rules, unless the case is one inherently unsuitable for a remote hearing, a challenge to an award purely on grounds that the ICC Rules don't provide for remote hearing is likely to face an uphill struggle.